crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Hello and welcome into the attorneys. Thank you so much for joining us tonight. Got a really interesting topic of conversation. Worker compensation, knowing your rights is the topic of our conversation tonight. We'd love to have you be a part of that conversation. You'll notice all throughout the program tonight at the bottom of the screen are ways you can join our conversation. It's always better when you are involved, and we would love to have you do so. Also, attorneys from Hollis, Wright are standing by all throughout the half hour. So while we are on the air, even as we speak right now, attorneys from Hollis, Wright are standing by live for a free, off-air, confidential conversation. So you can call them or text them to numbers to know, and you might want to jot these down. It's 844-LAW-TALK. That's always the good number to know, 844-LAW-TALK. Anytime you need them, somebody is there for you, or you can call them locally in the Birmingham area, 205-324-3600. Told you earlier, we're talking about workers' compensation. Our expert tonight from the firm, Alwyn Horn. Alwyn, good to see you,
David,
sir.
thanks for having me back. I like being here.
So you look like a young fella, all right? You still got a full good set of head of hair there. How long have you been in this legal this game?
I've been doing this for, I think we're going on 25 years. And my focus has pretty much primarily been in the workers' compensation job-related industry.
Wow, really, for
world.
25 years?
That's right.
Yeah, so hundreds of, thousands of these cases have come across your desk over the years.
I've seen a lot, and handled a bunch of cases. Unfortunately, the only thing I can say that's negative about that is the law has not changed that much in favor of the employee.
Not a lot of evolution there.
Not a lot. Well, maybe for the employer. You know that the Workers' Compensation Act was codified in 1987, and we're still dealing with the same rates and monetary payments of $1987 instead of $2020.
It's always interesting to me to hear kind of the reasoning for why attorneys get into, kind of stay committed to specific areas like this. For you, what's the driving force? What's the story behind this 25 years?
Well, I'd just say that this is something that with the firm I originally started with, they were focused on, and there are a lot of people, especially employees, that need our help. You know, in the state of Alabama and across the country, we deal with low minimum wage and low wages, and a lot of these people are working very hard, dedicated employees that have been in the same companies for years, and they don't have anybody looking out for them. And the Workers' Compensation Act, for somebody like me who's been doing it for 25 years, is easy. I know the ins and outs of it, but for someone who's working, the working man, the working woman, they need assistance, because when they're hurt on the job and they have to file a claim, they go to their employer, but their employer has an insurance company that has a team of lawyers and adjusters that are well versed in the law. They know what they're doing.
It's kind of David versus Goliath.
That's exactly right. That's the way to put it.
Yeah.
That's right.
Yeah.
So I like the opportunity to help people in that situation.
Yeah. Give Alwyn a few rocks and just knock that sucker
That's
down.
right. That's right.
That's all you need. All right. So, are there laws that protect injured workers? Are there laws on the books to looking out for that?
There are. In the state of Alabama, you have what's called the Workers' Compensation Act, and basically it's a no-fault system, meaning an employee can be doing something in the line, scope, and course of their employment. They can be carrying a heavy load, walking upstairs, working from a ladder or a scaffold, and just fall, lift, pull their back, have an accident that's nobody's fault. Mm-hmm. And the Alabama Workers' Compensation Act provides a remedy for temporary benefits. If you're injured and out of work for a while, you're entitled to a temporary portion of your wages. They are entitled to 100% medical treatment covered by the insurance company or the employer, at no cost to them, as long as the employer does. There are some restrictions there. The employer gets to pick the treating physicians, for example. And if there's a permanent injury that results in loss of access to the job market, or just a permanent impairment to the body, you're not 100% anymore. You're entitled to some degree of permanent benefits. And that all falls under the Alabama Workers' Compensation Act, which is in the Code of Alabama.
Now, it just seems generally fair to me that if someone in my employ gets injured, I'm going to want to take care of them. The law seems pretty straightforward. Where's the rub? Why the need for an attorney in this?
Well, that's a good question, because here's how I would explain it. I represent a lot of people that have been working for the same company for 15, 20, 25 years, or even 2 or 3 years, and they're good, loyal employees. And there may not be a rub so much between the employee and the employer, but you're not necessarily dealing with an employer when you're an injured worker. You're dealing with an insurance company.
Yeah.
And the insurance company's in the business of making money. A lot of us are. We live in a capitalist market, and I'm all for it. But they're in the business of making money, and so they're not necessarily looking out for the best interest from a medical standpoint or a relief standpoint of the injured employee. They're trying to count their dollars and make sure that they spend as little as possible, if that makes sense.
Yeah,
so that's a rub. A lot of times, and it's unfortunate, but you have employees that are concerned to file a claim. They're scared of retaliation. But just remember that the claim isn't necessarily against the employer. It's not against the employer. That's why they have insurance for incidents such as this.
Yeah. One of the things I like to do with you smart legal folks is make sense of terms that I think the common folks don't. You hear them, but you don't really know what the heck they mean. So put it in like normal parlance for us. Such a term is arising out of employment. All right. What does that mean?
In order for an injury to be compensable, or that is covered under the Alabama Workers' Compensation Act, where you're entitled to medical, vocational, or compensation benefits, the accident has to occur within the line, scope, and course, or arising out of the employment. In other words, you have to be doing something in furtherance of your employment or your job duties.
So you can't hurt yourself at home and blame.
That's right. And an example would be a lot of times people may be injured in an accident going to and from work.
Yeah.
And with certain, unless there are certain circumstances, that's not a compensable injury. I have cases where people are walking, on their lunch break or after work going to their car. Typically that won't be covered since they're off the clock, but a lot of times employees are required to park on the premises. Yeah. And under certain circumstances like that claim can be compensable.
Yeah. What about recreational or social activities?
There are some cases, for example, in the books, one that I always think is interesting, where you have a lot of traveling salesmen or saleswomen, and they're out there doing their job, and they may pull over on the side of the road to eat lunch or eat lunch in a restaurant. If there's an accident under those circumstances, they have to eat. Then it's compensable. Your entire time is in furtherance or benefit of the company you work for. But there's a case on the books where a fellow decided he's going to pull over and eat lunch, and he's also going to go pick some blackberries in a field down the way, and he fell and broke his leg, and that claim wasn't compensable because he was not on an errand or mission for the employee. He was engaging in a personal activity. Yeah. So that's kind of the fine line: personal activity versus furtherance of, the benefits of the employer.
Right, and kind of being able to kind of make that line, make that work.
And there are a lot of good case examples on the books, and but it's a simple standard to meet if you know what you're doing.
Right. That's why we have you here. All right, let's step aside. Our first break of the evening here with All on Horn. More with him coming up after the break. As we head to break, a reminder, Hollis Wright is all over social media, Instagram, Twitter, Facebook, you name it, as well as online on the web, all over the place. Just search Hollis Wright and you'll find all the different ways. A really super informational, educational resource you're going to want to take advantage of. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas: bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, That's obviously the primary focus of the show.
We love helping people. I think everyone at this firm feels the exact same way, that the reason we do what we do is to help people. And this show gives us the biggest platform possible to help as many people as we can in the community.
Welcome back into the attorneys. Before we return to our conversation with Alwyn Horn about workers' compensation and knowing your rights, a reminder, attorneys from Hollis Wright standing by right now to speak with you. That free, off-air, and confidential conversation is yours for the taking. 844-LAW-TALK or 205-324-3600. Alwyn, a question we've got here. I've been injured on the job. What type of benefits am I entitled to?
That's a very good question, and it kind of goes to the meat of what the Workers' Compensation Act is intended to do. There's several, and let's just start with number one, your medical benefits. Under the Alabama Workers' Compensation Act, if you're injured on the job and it's a compensable claim, then the employer or their insurance carrier is responsible for paying for all of your medical treatment that is medically necessary and related to that injury. Okay. As we previously discussed, the insurance carrier has the right to pick the initial treating physician, and there may be a non-specialist in occupational health doctor that then may refer to another specialist, a spine doctor or somebody, and each referral becomes the authorized treating physician. So once a referral is made by an authorized treating physician, the insurance company can't step back in and say, well, we don't like that doctor. He's too generous, or he or she's too kind, so we want you to go to this doctor. So that's one rule to think about. There are some exceptions. If you're dissatisfied with your treating physician, then you are entitled to a list of 4, what's referred to as a panel of 4 doctors, and select a new one. But that's a one-time option, and but we're familiar with all the doctors, and the insurance companies are too, and for the most part, you're going to get good treatment in the state of Alabama. The other types of benefits are your compensation benefits. When you're injured, and sometimes you have to come out of work because your injury prevents you from doing your duties, or you may have a surgery. Right. You're entitled to temporary total disability benefits, and that is you're entitled to 2/3 of your average weekly wage. Okay. Average weekly wage is determined by what your average wages were of the 52 weeks preceding your injury, and you're entitled to that the entire time you are out of work, completely off duty. If you are put on light duty and you go back to work, I represent a lot of people that work 60 plus hours a week, but a lot of times when you're put on light duty or restricted duty, meaning that you can't do all the physical demands of your job. I mean, employers will sit you at a desk filing paper just to avoid having to pay those benefits sometimes, or the insurance company will have them do it. And if you only get those 40 hours a week, then you're also entitled to temporary partial disability benefits, which is the difference between the 40 and the 60 hours you were making pre-injury. A lot of people don't know that, and something to note real quick is insurance adjusters are not required by law to advise you of your rights or advise you of the law. If you ask them a question, they have an obligation to tell you the truth, and for the most part, they're good. I always try to work with everybody. People typically are honest people, but just remember that's a good reason to get a lawyer. And we can talk about that later, is because you need somebody to push the right buttons. Getting back into the benefits, you also have what are deemed permanent partial or permanent total disability benefits. If once your treatment's been completed and the doctor's released you and put you at max medical improvement, let's just say you've had a spine surgery and he says, well, you've got a 10% impairment to the body, there's a way to calculate that and you'd be entitled to permanent partial disability benefits. We have a lot of people that may be, let's say, mechanics, 60 years old, might have a 7th grade education, 8th grade education, that have had 3 back surgeries, and there's no way they're going back to work at all. Right. And they would be deemed, in my opinion, permanently totally disabled, and then you would be entitled to benefits calculated for the rest of your life. And something to note is that the Workers' Compensation Act does not require a judge, these are judge-heard cases if they're not settled, they can't award a lump sum payment. The insurance company can pay you weekly for the rest of your life, but there are ways to negotiate lump sum settlements, and attorneys know how to do that, and we're familiar with that, and that's a benefit in getting an attorney also. Right. And then the last benefit would be vocational benefits or retraining. A lot of people who are in a heavy line of work or heavy industry might have a back injury, a shoulder injury, hip injury. They can't go back and do that heavy work, but they can do something lighter. And the Act does provide for the employer or the insurance carrier providing training for a new trade or education for a new trade. So those are the primary benefits.
And that's a whole whole host kind of runs the range, now it makes sense why you need somebody, because I would not have put all those pieces
Well,
together.
like I said, a lot of people, somebody that's been doing it 25 years, we're familiar with it. It's like looking at the back of your hand, so to speak. But for someone that is not a lawyer or familiar with the Workers' Compensation Act, and I have a lot of intelligent clients, they go online and they look at these things and they think they can handle it or come to me with questions. But it's not that easy. And, for example, a lot of times when people settle their claims without an attorney, the employer insurance carrier always wants to close those vocational benefits, because the vocational benefit, your right to that, stays open for 300 weeks from the date of the injury. You're looking at about 5 years, or is it 6 years? My math, it's closer to 6 years, whereas the actual statute of limitations in a claim is 2 years. And a vocational right means that if, let's say you settle your case for a 10% impairment rating for your spine surgery and you go back to work, and then after the statute of limitations runs, you can't do it anymore and your employer terminates you because lawfully, because you physically can't do the job. Well, if you'd kept your vocational rights open or vocational benefits open, you would have an additional 4 years to reopen the claim to say you can no longer do this job because of the injury you have, and you can get more benefits. Employers, insurance carriers, especially with people that aren't represented, want to close those benefits and those rights because they're getting a free bite at the apple.
Mm-hmm.
You don't understand, you're not, as an injured employee, you're not getting paid for that.
Right. How much of your day, your average day, is spent following up on all of those, holding people's feet to the fire, making sure nothing's falling through the cracks?
A large part of our job, this is why we've hired more people to help in this, is this is so fact-based and so personal to people because it's their livelihood for their families, for their children, making sure the income's coming in, making sure the bills are paid. Is their light bill going to stay on? Can they buy new clothes for the kids to go to school, simple things like that. So we are on it all the time. I spend an extremely large portion of my day on the phone.
Right, yeah.
I text, we email, but we're there because, and you got to think of it too, the insurance adjusters, some of them have a lot of claims and some of them are simply overworked.
Yeah.
So you got to stay on top of it. And, it's not all the time that your payment's late or your weekly payments intentionally being paid to you late. It's right. that they may be overworked. So you got to help. You got to push. Sometimes you just got to keep pushing.
And it doesn't really matter to the person who's not getting the funds that they need, does it?
Oh,
yeah. It doesn't matter if it's negligence or if it's oversight.
That's right.
The bill is due.
That's right. The bill is due. That's right. And even though there's 30 days before someone can be deemed late, or an employer and insurance carrier can be deemed late paying the funds, your bills. The debt collector doesn't wait 30 days.
Yeah.
So we understand that.
Yeah. All right, time to step aside. Our final break of the evening. If you want to join our conversation, please jump on the line and do so. Would love to have you join us here. A few minutes remaining. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WVTN 13.
Welcome back into The Attorneys. Just about 7 minutes remaining in the show, so time is running short. If you want to join our conversation, don't forget the attorneys from Hollis, Wright, standing by live to speak with you while we are on the air tonight. Those numbers, 844-LAW-TALK or 205-324-3600. Here with Alwyn Horn from Hollis, Wright, talking about workers' compensation. Let me ask you, in your experience, 25 years you've been at this, what are the different types of injuries that are commonplace relative to this?
That's a good question, David. You know, there are a couple of different types, and I kind of categorize them. You know, some people may not know some of these are compensable even, or that they're entitled to workers' comp benefits from exposures. But you have what's called a traumatic injury or a traumatic event. And what I mean by that, and typically what the law means by that, or how it defines it is, you know, we talked earlier about somebody working from a scaffold or a height and falling. You talk about somebody that may have a piece of heavy equipment fall on them or run over them. That's a traumatic sudden event that results in injury. That's a type of injury incident. Another is injuries are cumulative stress or repetitive nature injuries. We have a lot of people we represent that works in the textile industry, in mills, loading facilities, and they're using, for example, their hands all day, every day, or their arms all day, every day for years, where they're manipulating parts, you know, 500 to 1,500 times a day, performing the same motion over and over and over again. And over time, you know, you might develop carpal tunnel syndrome, de Quervain syndrome. You know, your rotator cuffs may wear out. And that's called a cumulative stress or repetitive nature injury. You know, if a doctor, a lot of times they will, just because it's obvious, someone that's been doing the same thing for 20 years, their shoulders wear out and they need shoulder surgeries. That's a cumulative stress or repetitive nature injury. And I'll point this out, it is important to have a doctor, a medical provider, you know, establish the causal relationship between, you know, the activity and the injury itself, and that's why it's so important that you get to a good doctor, and that's why the insurance companies like to make the selection. But then you also can have chemical exposures or other exposure-related cases. We have people that work in paint manufacturing plants, you know, welding plants, coal industry, and they're exposed to coal dust or certain types of dust or chemicals that can cause a lot of bronchial problems. We see a lot of cases of pulmonary problems and breathing problems that are compensable. Again, it's important to have the causal relationship, but that's a good reason if you even think that you might have been exposed to these circumstances or something may be causing these conditions for you, that you get to a lawyer immediately to make sure you go and you take the right steps to try to define the injury originally. You don't want to get backed in the corner where you're digging out of a hole, so to speak. Get somebody that knows what they're doing to help you do that.
With those categories, is the compensable opportunity, I guess, or potential, does it differ much?
It doesn't differ, but the burdens of proof can be more difficult. There is a different burden of proof in establishing a relationship between a traumatic event and an injury and a cumulative stress or repetitive nature injury. The burden of proof is more difficult for us as attorneys to establish that cumulative or repetitive nature. And a lot of times just because of maybe the lack of knowledge about chemical exposure or what a chemical can do, and the fact that it may affect 1% of the population with the 99% it infected, that can make our burden of proof more difficult. So yeah, the overall compensation does not change, but the burden of proving the claim is compensable can become more difficult in those types of cases. You know, with the traumatic injury, I'll just say, you know, these cases are judge tried, they're not jury tried. A lot of things people don't realize, and this is one of the biggest things we have to overcome with our clients, is because the amount of money someone's entitled to for their benefits was established in 1987 when a Coca-Cola was 10 cents and now it's $1.50, is why is my claim not worth more? You know, in a workers' compensation case, you don't get mental anguish, you don't get pain and suffering. You know, your case is purely valued on your degree of impairment, your percentage of impairment, or your inability to return to the job. And if you're anything less than 100% disabled, the most you can ever get, the most, I'm not saying you'd be entitled to this even, is $220 a week for 300 weeks. So, you know, it may be clear as day that you can't go back to your line of work for 20 days, but the most you're going to get is $220. That's a $220 cap for permanent partial disability benefits. After you're released by your doctor, placed at maximum medical improvement, $220 is the most you can get. If you're 99% unemployable, $220 based on $1987.
Wow. Let's talk about third-party claims. Is that a common?
It is, and here's another good reason to get a lawyer. You know, Josh has been on the show, Carter, all these other lawyers, great lawyers in this firm, are great at handling these third-party claims. A lot of times when you're dealing with employer-related accidents or claims, you know, we deal with a lot of contractors and subcontractors, and they're building projects, or they're just a lot of different companies that may work within one factory industry. One company may be required to operate heavy equipment and move things, while another person may be responsible for cleaning. Point being is a lot of times a third party, not your employer, but an employee of another company is responsible for causing your injury. In Alabama, the Workers' Compensation Act is an employee's sole remedy against their employer, but that does not prevent them from filing a claim against a third party or a third party employee for negligence.
Right.
And you're dealing with, you know, in those cases or jury tried cases, you have mental anguish, pain and suffering. You know, the value of the claim is left up to a jury. And it's a big difference in terms of the amount of compensation you can receive. It's more equitable, it's more fair to the injured employee. And I'll say this about that, when another good reason to get an attorney. There is a relationship between an insurance company for an employer and an insurance company for a third party, because if you have a third party claim as an injured employee and you've received all these workers' compensation benefits, then the insurance company for the employer that has paid those benefits to you is entitled to be paid back if you have a recovery from a third party insurance company or a third party employer. And it's called subrogation, and it's just another example of something the common individual may not know, that they can back themselves in a corner or not realize the value in assessing that when you're handling your claim. You know, you want to maximize your recovery, you want to maximize your compensation, and hold all people accountable and responsible. So we know what to look for, and we look outside the box, so to speak.
You have about 30 seconds remaining. So from you, just kind of a final thought for our viewers tonight.
I would just say this, you know, there are a lot of, like I said, loyal, hardworking employees out there that don't want to cause any trouble with their employer. But just remember this, that if you're hurt and you're seriously injured or you feel like you have a problem, you got to look out for yourself and your family. Your employer, I find a lot of times are helpful to the employee, but your claim is against the insurance company.
Right.
And they're about making the money and saving the money.
Yeah.
So just remember that, if that's a reason. Get you an attorney. We know the ins and outs of it, and we may evaluate the claim, and there may not be one.
Right.
So,
yeah. All right. Alwyn, good to see you.
thank you for having me.
Thank
I
you so
appreciate
much.
it.
Appreciate Alwyn being with us. Appreciate you being with us as well. Thanks so much. See you next time.
Thanks for watching The Attorneys, sponsored by Hollis Wright.